boy, oh boy, oh boy. Y'all can hear me going to that song. Good. Yeah, yeah. Give me that thumbs up. Give me that thumbs up if you can hear me. Listen, honey, my schedule is crazy now, right? Crazy. I don't know why. I just can't. It should have left well enough alone. I don't know why I want to crowd my damn schedule and shit, but hey, what's good with it? You know, I don't do this. I don't do nothing until y'all let me know y'all can hear me, honey. I need to see them thumbs up. Good, good. All right. All right. I see Karen was first. Ooh, whisper in the building. 4 day this morning. Yes. Hey, Elvira. Hey, Chi-Town OG. What's good with it? Well, while I was up here getting my dose of reality show in, I was like, okay, we got a drop from Illinois. And I looked at, well, you know, I said, okay. I looked at it, and it was the Jbo'S responding, right, to the motion in limine. So it's just 14 pages, right? So it's not that bad. So we can knock that out. So, honey, I had to change it. I had to change the breakdowns to breakdowns and analysis. Hope I spelled that right. I think I did. Make sure. Because everybody using the word breakdown. Whether they're breaking it down or not, they using the word breakdown. So, you know, we always try to be different. I used analysis before, but, you know, I'm just messing around. I'm just being funny petty. Yes, honey. But listen, no, this I have to say this. This goes out to Jbo'. Lord have mercy, Jbo'. I don't know what you're doing. Lord have mercy. Now you know you my internet husband. But if you go get in additional trouble, you're gonna be my internet ex-husband because you're gonna be in jail. And I'm gonna look for laws to see if I can divorce your ass because you done been goddamn locked up for some additional shit. Oh my goodness. Somebody told me that Jbo'S community board was off the chain today. So I went and looked, and when I tell you, I got back to 2 days in, and I was like, are you serious? I didn't even know that, you know, he was back into it with, you know, with all these extra people. I'm like, God damn. Like, I ain't never seen nobody campaign for more trouble. Like, Jbo', please leave this shit alone. You see how, you know, how they, whatever they used to for probable cause before. You supposed to come out and demonstrate that ain't you. You know, come on, God damn. And I'm not just saying that who he's into it, you know, back and forth. I can give less than a damn about any of that, but I'm just saying the point is, come on. Come on. Like, come on. Shit. But anyway, let's get into this and see what Jbo' is talking about. All right. It says the response to government's consolidated motions in limine by defendant Robert Sylvester Kelly, right? So what this means is that, okay, you know, she did their motion in limine. She jumped on Milton Brown attorney's motion in limine from 2 through 5. The issues that attorney raised from 2 through 5. The government filed a motion in limine as well, and she's responding to that one, right? So apparently she has a issue, and she's going to probably explain why the what the government is saying should be denied or something like that, or why the reasons why hers should be granted, right? I'm not sure, but we can get into it. We can figure it out as we go. And that's how we do it. And I'm not around the front, so let me get to reading. All right. It said, now comes defendant Robert Sylvester Kelly, buying through his counsel Jennifer Von Jean, in response to the government's consolidated motion in limine as follows. Introduction. The government's 40-page consolidated motion in limine, government's motion or the motion, consists of 16 parts, some of which attempt to prevent Mr. Kelly from effectively confronting witnesses while asking this court to preclude any possibility of a fair trial by flooding the proceedings with prejudicial propensity evidence. Remember, I told you propensity evidence is not allowed because it just it's prejudicial because it shows someone's propensity to commit a crime. It's not allowed in that order. It's allowed when it is used to show something like someone's intent or motives or something like that, right? It said where parts of the motion simply remind Mr. Kelly to follow the rules of evidence and provide notice that the government intends to try to prove its case. Mr. Kelly responds that he intends to abide by the rules and object as necessary. Mr. Kelly objects to MIL NOS 2, 3, 5, 7, and 8, and 15 of the government's motion, joins the motion with respect to number 4, has no objections to number 1 or 11, and defers to the courts on the remainder, reserving the right to object as necessary. He responds to each part of the government's motion in turn. All right, and just keep in mind all these motions and stuff, these are pretrial motions, Rule 12 type motions. They have to file them in a in a timely filing, or they lose their right to rebuttal this at a later time, right? And also with any issues up front or what have you, just say something goes awry at the trial or what have you, and it ends up in a conviction, then without these things being on record preserved, you can't challenge them when it comes time with the well, you shouldn't be allowed to challenge. Let me say that when it comes to the post-conviction phase, whether it be post-conviction motions or on the appeal. All right. Number one, it says motions to protect the identities of minors 1, 3, 4, 5, and 6. First, Mr. Kelly has no objection to the alleged minors testifying using only their first names or to minor one's mother doing the same. Mr. Kelly agrees to refer to them in kind. That said, some of these individuals are already well known within the public domain. Minor one and her mother are already public figures because of the previous case in which Mr. Kelly was acquitted. In addition, Minor 4 gave an interview to NBC's Dateline in 2019 and may have well made other statements to the media. It is not known to Mr. Kelly whether any of the other minors have had similar media involvement. Therefore, while Mr. Kelly does not object to using first names, he does assert that to the extent that some of the minors' last names and identifying information is already widely known, it was not through his own public disclosure. Mr. Kelly has no objection to refraining from eliciting disclosure of the addresses, names of family members, and places of employment of the alleged minors one mother, or Lisa Van Allen, individual D. As to the government's request that the court enter the attached protective order, Mr. Kelly agrees to a protective order that corresponds to points 1 through 3 supra motion at 5, right? So it must be going to they explained it above, so let me see. When it says supra, it means it's explained above. Hmm. Let me see where the kind gave for him. to object using the name to a certain extent emotional subjects referring to the disclosure of the well, it seems like they pretty much agrees to what the prosecutors has said with regards to not allowing them to use their names and stuff like that. So that's what it seems like to me. They agree to it. Okay. It says two, motion to preclude evidence of victim's sexual history. Citing to Rules 412A and 403, the motion asks for an order precluding defendants from eliciting on cross examination or otherwise introducing evidence or making arguments as to the sexual behavior of the victim witnesses with individuals other than Kelly or others at Kelly's direction, as well as any evidence of any purported sexual predispositions. Motion at 6 and 7. At the outset, Mr. Kelly has no intentions of introducing any evidence of victim witnesses' sexual behavior for the purposes of establishing sexual predisposition. That said, the prior sexual behavior of the victim witnesses may be relevant to questions surrounding consensual sex acts with Mr. Kelly when the victim witnesses were not minors. Indeed, Mr. Kelly maintains that as to certain victim minors, he never had sexual contact with them when they were minors. Oh, okay. So we got a little a little insight. Hold on. Hold on. So we got a little insight. So apparently one of his defenses with regards to having sex with the minors is that he never had sex with them as minors. So she's either going to do a couple of things. One, like remember I told you before they went to trial, before Cannon went to trial, she must be going to try to age them, right? By saying, an example would be like this videotape was made at a later date when this particular person was at the age of consent, right? Okay, most likely it's probably going to be in the age of consent of that particular, what's all happening in Chicago. So it'll be whatever the age of consent is in Chicago, right? So she'll probably try to use that. That's usually a good one to try. Probably also try to, that's with the tape. She also probably try to challenge the years. If she doesn't, like if she challenged the years in which the tapes were made, like challenging her memory, like you said that this happened in 1993. Well, are you sure it didn't happen in 1994, 1995, or whatever when you was at the age of consent, right? Then she could loop back in the tape saying, well, if that's the case, then how do you know that this tape wasn't made in 1993, 1994, 1995, or something like that, right? So she has a little working room. I'm not sure how she would, which particular method or style she would use to age them, but that's just a couple ways of doing that. Let's see. Okay, indeed, Mr. Kelly maintains that as to certain victim minors, he never had sexual contact with them when they were minors. Accordingly, Mr. Kelly objects to the exclusion of one, any evidence regarding sexual conduct of witnesses who are not alleged victims identified in the indictment. Number two, any evidence that falls within the exceptions laid out in Rule 412B. And three, any exclusions based on Rule 403 that is not narrowly tailored to protect Mr. Kelly's Sixth Amendment rights. Okay, that's a lot. All right, so this is only 14 pages, so I can kind of go through this, and I'll do a recap on the message board probably tomorrow. It says the exclusion of one any evidence regarding sexual conduct of witnesses who are not alleged victims identified in the indictment. So meaning any uncharged acts, right? Any witnesses that's getting up there talking about, just to show, hey, other bad acts, right? So she wants to tackle that. It says any evidence that falls within the exceptions laid out in Rule 412B. I don't know what that is right off the top of my head because nobody knows the rules like that right off the top of their head. But she is saying like, anything that should be automatically ruled out. Because that's going to go through the rules of exception, the rules of evidence, whether and if it's not, an exception to it, then it shouldn't even, get in anyway. Oh no, I'm sorry. She wants the ones that falls within the exceptions. That fall. She wants the evidence that falls within the exceptions uh to be excluded as well. Wait a minute. She according to hold on. Wait a minute. She's asking a lot. Hold on. Okay, I'm ready. That as a certain victim minds, he never had sexual contact with them when they were minors. According to Mr. Kelly objects to the exclusion of any evidence regarding sexual conduct witnesses who are not. Objects to the exclusion. Why would you object to the exclusion of that? And then three, any exclusion based on Rule 403 that is not narrowly tailored to protect Mr. Kelly's Sixth Amendment right. But that means you're okay with it, except for number 3. Let me keep reading. As a preliminary matter, the motion is not clear as to who the alleged victim witnesses are that the government asked for this ruling to apply to. The voluminous discovery in this case involved many women who purportedly had sex with Mr. Kelly who are not identified in the superseding indictment. So that tells us right there that they have some uncharged acts coming in. So it's more people taking a stand. So listen, we got more people taking a stand. We got statements that everybody, including the damn dog, believe. People that might be included in the conspiracy, people that they were told about the conspiracy, maybe the co-defendants, everybody. Everybody's coming in. The fuck is going on? Hold on, let me keep reading. And I'm telling you, this type of stuff, when I read like massive stuff like this, it really, knocks me off my goddamn square. Let me keep reading though. So it says, okay, many of whom were legally able to consent, and others from whom the proffered evidence provides a genuine dispute as their age at the time of the sexual act. So I told you where she was going to go with it. She's going to try to age them. She's going to try to do something with those minors. Okay, let's go. It says, to the extent that the motion asks for the court to preclude cross-examination or evidence regarding witnesses who are not identified in the superseding indictment, it should be squarely rejected. Because Rule 12's express terms apply only to witnesses who are victims, and because the government has not explained how adult females who had consensual sex are victims, its motion in limine pertaining to evidence of other sexual conduct of these witnesses should be denied. She got a good point. Unless those victim witnesses, who's probably going to come in as uncharged acts, unless they are talking about some type of abuse or or they're talking about the rules or some tape, they were taped or something like that to show some type of pattern of behavior, what have you. Not to get confused with propensity evidence, but some kind of behavior, what have you. She is right. It should be denied. All right. And we have a case law. It says, in addition, the government's assertion that all evidence of sexual conduct of minor 1, 3, 4, and 5, and 6 is inadmissible under Rule 412 is unavailing. Under Rule 412B and C, evidence of specific instances of a victim's sexual behavior are admissible to prove consent and where exclusion would violate defendant's constitutional right. So remember, it's a victim's right where you can't cross-examine them with regards to their sexual history. Okay, remember that. Accordingly, courts have admitted evidence that involves sexual conduct for purposes unrelated to sexual predisposition, such as establishing that a victim lied about her age and for arguing that allegations of sexual abuse are false based on history of making false allegations. Oh, okay. Case law. To mount a defense against the government's extensive allegations, some of which date back almost 30 years, Mr. Kelly must be permitted introduce evidence. Okay, must be permitted to introduce evidence and make arguments that would impeach claims of minority, assert a mistake of age, okay, or establish a timeline among other defenses. Okay, all right. So she's giving us a lot of information here. All right. So she's giving us a peek at her defenses. And again, you can use more than one. Remember, I told y'all you can use several. All right. So impeach the claim of minority. All right, that's pretty much self-explanatory. Assert a mistake of age. Remember, we saw that play. They tried to get that in at the last minute in the New York trial, right? So that's mistake of fact. That is that's an exculpatory defense. It either justifies or excuses the behavior, right, of the defendant. Now, it doesn't give them 100%, like, you're not at fault 100%, but it does mitigate his criminal liability, right? Okay, so he's given a reason why this happened, why this particular sex happened with this person who was underage, okay? And it says, or establish a timeline, which when I say maybe, when she means that, maybe she's going to try to age those tapes or age those girls. And she says, amongst other defenses, okay? It says, similarly, the government's sweeping claim that any inquiry or evidence related to victims' sexual history should be excluded under Rule 403 is unsupported and premature. Motion at 8. When evidence is relevant and otherwise admissible, exclusion should be narrowly tailored, and the prejudicial effect of the offered evidence must substantially outweigh its probative value. Case law. Consequently, it is not enough for the government merely to claim that any evidence of any sexual conduct would be marginal at best, when the admission of specific instances may be necessary to secure Mr. Kelly's rights under the Confrontation Clause. Okay, here we go. Confrontation Clause again. Motion at 8. And case law. Remember, the Confrontation Clause deals with the rights to, face your accuser. Ask them questions, cross-examine them. Right? Make their challenge their testimony, right? To see, challenge it for their memory, consistency. If they're lying, maybe they can be impeached. All of that. Let's see. Okay, and it says the Fourth Circuit of 1992 rejecting prejudice argument under Rule 403 and admitting complainant's past allegations of sexual abuse, because in order to confront the complainant effectively, to elucidate the facts and legal issues here in question fully, and to present a defense in constitutionality viable trial, defendant must be allowed to set before the jury the proffered evidence of ulterior motives. Oh, okay. The government sweeping forward the re-argument, which attempts to broadly exclude evidence that is explicitly admissible under Rule 412B, must be rejected. Okay, so remember I told you how she likes to do it. Now she is raising issues with mandatory law and primary law. So this is a pretty good motion, right? Okay, because she is asking the judge, hey, she's pointing out the primary the mandatory law, right, which must be followed. Primary law, the rules and procedures of the court proceedings, right? So she's saying this must be followed according to the law, Constitution, as well as the rules of evidence. This is pretty good so far. Says finally, the government statement that Mr. Kelly must submit a motion under 412C1 before introducing certain evidence with regard to the alleged victim is not in dispute. Mr. Kelly has every intention on complying with the federal rules of evidence, including 412C1, and will provide notice as required by the rules. Number 3, motion to bar evidence and argument related to consent. By their own statements, all but one of the alleged minors had engaged in sexual relationship with Mr. Kelly while they were consenting adults. In addition, the entirety of the sexual acts charged in superseding indictment took place between 19 and 26 years old. She is trying to age them. The age of the alleged minor and the veracity of claims about their age at remote points in time are of central importance in this case. She referred to them damn tapes. So much so that proving any of the alleged minors was old enough to consent would be a complete defense to all counts involving that alleged minor. Did she say but she said all but minor one? Or what? She aging them. Goddamn, 19 to 26. Hold on. And the entirety of the sexual acts charged in the superseding indictment took place between 19 and 26 years old. I don't know how she gonna make that work. Because if I'm not mistaken, I saw one was from between age 12 and 13. So I don't know how she gonna pencil whip this. I don't know how that's gonna work out. But she's good, so don't worry about it. Let me stop right here. It says the age of the alleged minors and the veracity of claims about their age at remote points in time are of central importance in this case, so much that proving any of the alleged minors was old enough to consent would be a complete defense to all counts involving that alleged minor, right? While Mr. Kelly does not intend to argue that minors are legally able to consent to sexual acts with adults, he objects to excluding evidence and argument related to consent because he cannot be precluded from arguing that the alleged minors were old enough to consent. Wait a minute now. While Mr. Kelly does not intend to argue that minors are legally able to consent to sexual acts with adults, does not argue. Okay. Oh, okay. Okay, I'm gonna say she done lost her damn mind. Oh, it's too early in the morning. Okay, she's saying that she's not finna argue that minors are able to consent to sex with adults. I'm finna say now, wait a minute now. Shit, what you trying to say? She says she's not gonna make that argument. He objects to excluding evidence and argument related to consent because he cannot be precluded from arguing that the alleged minors were old enough to consent, which she's meaning is that goes back to that 19 to 26 years old. she's some kind of way is going to age them to be between 19 and 26. Okay. It said, relatedly, Mr. Kelly objects to the government's motion to the extent it seeks to prevent Mr. Kelly from refuting the government's proof of inducement. And remember, I told y'all back when the government first put in that motion in limine, it was to shut down defenses. This is pretty much what she's saying, going through this document. You're trying to stop me from defending him here, there, and here. And that's what she's arguing. Okay. It says to prove offenses under 18 USC section 2251A and 18 USC section 2422B, the government must prove that Mr. Kelly knowingly persuaded, induced, enticed, or coerced the alleged minors into engaging in sexually explicit conduct for section 2251A, or to travel in interstate commerce to engage in sexual activity for section 2422B, while Mr. Kelly concedes that consent is not a defense to section 2251 or section 2422 offenses. It is also true that sexually explicit conduct with a minor is not per se evidence of inducement. Okay, so right there, she is attacking that element. Okay, she is saying that, and it's kind of like what she said, but no, not really. Let me just make this fresh. So she is saying that just because they were maybe not of age to consent, that doesn't necessarily mean that he induced, enticed, persuaded, and coerced them into having sex. Okay. She says, put differently, the government is not relieved of its burden of proving inducement simply because it established sexually explicit conduct with the minor, which is what I just said. I always do that shit. If I just keep reading, she will answer me. All right. It says, Mr. Kelly must be permitted to challenge evidence of inducement, which may require cross-examining the minors about their conduct, not to demonstrate consent, but to negate inducement. To the extent the government attempts to prevent Mr. Kelly from challenging inducement, he objects to this motion. This one, I'm trying to tell you, woo, she's slicker than Texas. Oh, baby. Oh, but I love it. I love it. Because she's trying to get around that little piece where you don't supposed to question them about their sexual history with these sexual cases like this and shit like that. And she's also saying that she needs this evidence to knock out that element. Because remember, a jury must find you guilty because they got to convict you on all them elements listed in that particular count. She's trying to circumvent that. This is a good strategy. All right, number 4, it says motion to prevent the public display of child pornography during trial. Mr. Kelly joins the motion to prevent the publication of video clips allegedly containing child pornography to the gallery during trial. Okay, that makes sense. Number 5, the government's intended evidence of polygraph examinations. Without conceding any of the arguments in the motion, Mr. Kelly acknowledges the government's intent to present testimony and documents of polygraph examinations allegedly taken by the witnesses in this case. To the extent the government intends to introduce the fact that polygraph examinations were used by defendant McDavid in support of its obstruction charge, Mr. Kelly does not presently object while reserving his right to object at the time of the trial. That said, Mr. Kelly does object to testimony about the results of the polygraph and the introduction of questions presented during the polygraph examinations. Any substantive use of the polygraph examinations that would bolster any government witness's testimony should be prohibited as both unreliable and unduly prejudicial. So now she's trying to hit on the results of the polygraph. You know, usually polygraphs are not it admissible in court, right? Because it's unreliable, unless both parties agree to them and whatever the circumstances, whatever. That's what she's trying to make the case with regard to this. Wait a minute. But here's might be a problem. If the government introduces them in a way, all right, because the trick of getting this evidence in, you have to introduce it in a certain way and show its relevancy. If they introduce it in a way to where it shows that there was a conspiracy going on and it can be proven by these questions, then the government may, that may be a counter to what she's saying. Like, but here is further proof that there, that there was a conspiracy. And here is, look at this. Look at these questions. Yeah. Give me 1 minute, y'all. 1 minute. Y'all straight? Oh Lord, the damn goddamn shit is back again. You please get that goddamn spam. All right, give me 1 minute, y'all. All right. Sorry about that, folks. Okay, what was okay, without let's take another. Okay, to the extent the government intends to introduce the fact that polygraph examinations were used by the defendant McDavid in support of its obstruction charge, Mr. Kelly does not presently object while reserving his right to object at the time of trial. That said, Mr. Kelly does object to the testimony about the results of the polygraph and the introduction of questions presented during the polygraph examination. Any substantive use of the polygraph examinations that would bolster any government witness's testimony should be prohibited as both unreliable and unduly prejudicial. The government fails to explain why it would need to present testimony from the polygrapher when the individuals who were allegedly subjected to the polygraph examination can simply testify about having participated in the polygraph examination. She has a point because because I see what she's saying. It could be, prejudicial because that's like, a little, it's a little extra, right? To the extent the court permits the polygrapher to testify, the testimony should be limited solely to establishing that a polygraph examination occurred. Okay. So did she want the questions and the results out? She want the results of the polygraph. Okay. She may have a point. Because now, if you're sitting up there allowing them to testify with regards to the results of the polygraphs and stuff like that, did she say questions as well? I can't remember. Wait a minute. Not just the government telling my documents. Polygraph examination, alleged taking extent of government intent to disrespect. Polygraph examination, support of the results of it. The results. Okay, she may have a point because now it's really looking like you're trying to say that, oh, and by the way, yeah, she might have a point because you really don't need the results. You really don't, because if you got the person that took the polygraph, you got the polygrapher, the results really doesn't matter because proving whether or not they passed or failed the polygraph, I'm not sure how the government would work that into its line of questioning, right? Because, oh, should I say examination? I'll say examination, but to be to use legalese, but the questioning, right? So because what would the results show? The results just show whether they passed or failed, and it just shows the results is going to speak to the actions of the person that took the test, not to the McDavid's role and R. Kelly's role, because the questions they didn't ask any questions about well, did R. Kelly tell you to recoup the tapes, and did R. Kelly give them, unless they got some questions like that, with regards to R. Kelly and McDavid. I don't see where the results would be necessary. So I see her, I see the point. But of course, we ain't on the case. So we got to see what the government says. It's at number 6. It says, notice regarding introduction of false records alleged in the superseding indictment. It says, Mr. Kelly objects to the introduction of the memorandum prepared in connection with statements made by individual D on relevance grounds. The government alleges that Mr. Kelly and defendant McDavid caused individual D to make a false statement to private attorneys who then memorialize those statements in some type of memorandum that was provided to the Cook County State's Attorney's Office in 2008 and eventually made its way to the Office of the United States Attorney. As a matter of law, this memorandum is not relevant evidence since the government has proffered no evidence that Kelly or McDavid created the memorandum or made the false statements contained in the memorandum. Mr. Kelly contends that to sustain a conspiracy to commit a violation of 18 U.S.C. 1519, the government must show that Mr. Kelly or a co-conspirator make the false entry or false statement. It is not sufficient to show that they persuaded another to do so. It is not sufficient to show that they persuaded another to do so. Since the government proffered evidence, okay, as a matter of law, this matter is not relevant evidence since the government has proffered no evidence. Okay, let me read on. It said, moreover, the government has proffered no evidence that the individual D herself had any knowledge that a memorandum was being prepared in connection with her alleged statements and shared with state prosecutors who would eventually share it with the federal prosecutors more than a decade later. In short, the creation of this memorandum cannot, as a matter of law, constitute a false record, nor is there any evidence that suggests that it was prepared with the knowledge of any the defendants or even individual D. She must be rushing with this. Okay, so she is talking about when they said that R. Kelly and them calls Lisa Van Allen to give the cops and them a false report, right? A false record. That is what she's talking about. Let me see. Let's see if there's anything else in this we need to address. Okay, so she's trying to argue that it shouldn't be allowed because it's no evidence to show that um, Kelly or McDavid created the memorandum or made the false statements contained in the memorandum. It is saying that Lisa Van Allen is the one that gave this false statement, and this is the record they handed over to the feds. I think she may lose on this point because this will show as a part of the conspiracy. Lisa Van Allen's testimony should probably be that they made her lie, whatever. As a result, here's the false report that showed where I lied. So I don't think she's going to win on this. It said, relatedly, Mr. Kelly objects to the introduction of any police report that allegedly contains false statements of minor one. Such evidence is irrelevant for establishing that Mr. Kelly or any co-conspirator made false entries in any record or document. As stated above, even assuming the government can demonstrate that Mr. Kelly persuaded minor one, see where she's going with this? But like what I said with Lisa, to make false statements to the law enforcement, such evidence would be irrelevant to the question of whether Mr. Kelly and any of his co-conspirators made false entries in any record. I don't think, okay, you done pencil whip the hell out of this, and I don't think that's going to work because for the reasons why I said before, and she's raising that argument. She's trying to say that you're not showing where Mr. Kelly, and so the government can estimate above even assume that. So she's not saying that the government, you know, is showing that R. Kelly or Mr. McDavid made any false records or told them to make the false records. But they're saying even if they did persuade them to make the false records to the law enforcement, it would be irrelevant to the question of whether Mr. Kelly and any of his co-conspirators made false entries in any record. She is trying to combine R. Kelly and Mr. David making false claims of records to the police with Lisa doing it. And that's not what the government is saying. The government is saying that they caused Lisa to make the false record. Thereby, the false record should be allowed as proof that she made a false report because she's going to get on the stand and say, yes, she made a false report, and here's why. I did it. But in actuality, this is what happened. This was my part in recouping the tapes, and I got the money, and I've got all these guys involved and all that other strange shit that went down. Okay, number 7, it says notice of intent to admit direct evidence of crimes charged. The government's notice of intent conflates proving its case with asking for a carte blanche to introduce inflammatory evidence suggesting that Mr. Kelly had a violent and abusive character. Specifically, it plans to introduce evidence of physical, emotional, and sexual abuse of minors 1, 3, 4, 5, and 6 for purposes of showing enticement and coercion necessary for the Section 2422B charges and as direct evidence of the Section 371 charge. Motion 2425. While some of this evidence might be relevant, Mr. Kelly objects to admission of any evidence that is not directly relevant to the crimes charged and objects to any evidence whose probative value is substantially outweighed by a danger of unfair prejudice. She has a point. It says Federal Rules of Evidence 403. Critically, the government has provided a couple of examples of evidence of violence it seeks to introduce, but has failed to put Mr. Kelly on sufficient notice of what specific acts of violence it intends to offer as evidence. So most likely it's probably that damn tape. They said the tape of him hollering and screaming at her about the stealing of the watch or whatever the fuck it was. That's probably coming over here too. Or maybe there's some other acts of violence. I'm not sure. But that's just one that comes to mind. Let me see. Because it won't be that, because this was regards to minors 1, 3, 4, 5, and 6. So it's something else. And remember, it doesn't have to be tapes. It could be just a testimony, right? Because testimony is evidence. So no. So right here, they're not talking about Van Allen. I don't think. Let me make sure. Right. They're talking about just the minor's charge. All right. Sorry about that. It says allegations of acts of violence that were not intended to introduce. Wait. Hold on. Wait a minute. Okay. Going back to that little block of information, here's the thing, right? If that charge is sexual abuse, and I don't know what it is, but the charges are. If that charge is sexual abuse, remember I told you anything about domestic violence, emotional, whatever, you can stick that in a charge of sexual abuse. However, you cannot stick sexual abuse in a charge of domestic violence, right? So she's probably going to lose on that block. All right, let me read this. It says allegations of acts of violence that were not intended to induce interstate travel for sex are irrelevant to the elements of Section 2422B. And they have to convict via the elements. It says similarly, acts of violence that are unrelated to the conspiracy charges are not relevant. When minor one alleges that she had a long-term relationship with Mr. Kelly, which continued for nearly 10 years after she became an adult and for several years after she allegedly made false statements exonerating him on previous charges, not every allegation of violence during a 15-year period will prove the elements of Section 371. She has a point. Case law, it says on October 29th, 2018, excluding testimony that co-defendant participated in crime because of domestic violence by defendant, where that fact did nothing to prove elements of armed robbery. Similarly, what is it? Intimidated acts of alleged abuse by Mr. Kelly are not proof of a conspiracy, and is not conceivable that every act of dating violence or other violence against the alleged victims relates to obstruction of justice. She has a good point. She has a good point. Why would the government put the acts of violence? It has anything to do with the unless they're trying to say those acts of violence were a part of the, like, threatening them or whatever, not to say nothing about the alleged crimes or anything like that. That's the only thing I can kind of see. Maybe they got something different. Let's see. Okay, it says Northern District of Indiana, January 15, 2014, expressing concerns about the relevance of specific incidents of violence on the part of individual co-conspirators that were not evidence of concerted action in a RICO analysis. even for evidence of alleged abuse that has some relevance. The court should conduct an analysis under Rule 403 on an individualized basis to ensure that the evidence is not overly cumulative or prejudicial, particularly where the 13 count superseding indictment strings together charges that are unrelated in time, involve different alleged victims, and require proof of distinct facts that could allow for extensive and drawn out testimony. There is a strong potential that the abuse evidence the government references will end up serving as prejudicial propensity evidence, right? She keeps using that. And I told you how she writes. She likes to put pressure on the law and the judge and everybody else. It says to avoid this risk. You see how she invokes, his, hey, this could be a potential fucking violation, and I will get your ass on a post-conviction motion and an appeal. To avoid this risk, the court should delineate precisely the legitimate ends to which the evidence could be applied and allow the use of other act evidence only when its admission is supported by some propensity-free chain of reasoning. Just case law. That's not a bad argument. Okay, number 8. Motion for prior notice concerning Rule 608B, impeachment. Without any authority whatsoever, the government audaciously moves this court to put a gag order on Mr. Kelly's defense by barring impeachment evidence, including by asking questions on cross-examination, except upon prior notice to the court and the opposing party outside the presence of the jury. Motion at 26. It is uncontroverted that there is no general requirement that either side give notice of impeachment evidence. Case law. While there is an obligation on the government to provide notice of intent to use prior bad acts evidence under Rule 404B, Rule 608 does not contain that same requirement. Case law. It says on the Western District of New York, June 28, 2022, held that one in a line of Second Circuit cases saying no notice required under Rules 608 or 609. Well, she might have she might be pretty decent on that. It says to defend himself, Mr. Kelly must be allowed to expose biases of government witnesses through the use of impeachment evidence. Exposing witness bias is at the core of the confrontation right. Oh, okay. It says, case law, it says, according to the Seventh Circuit, bias is one of the 5 acceptable methods of attacking the credibility of a witness's testimony. 1, attacking the witness' general character for truthfulness. 2, showing that prior to trial, the witness has made statements inconsistent with his testimony. 3, showing that the witness is biased. 4, showing that the witness has an impaired capacity to perceive, recall, or relate the event about which he is testifying. And 5, contradicting the substance of the witness's testimony. Case law, which is all the things you need to do to make the witness testimony unreliable. It says the admissibility of evidence attacking credibility is limited only by the relevant standard of Rule 402, citing Wright and Gold, Federal Practice and Procedure, Section 6092 in 1990. Accordingly, this court should reject the government's bald attempt to preemptively bolster the credibility of its witnesses, more than a few of whom have made prior inconsistent statements under oath, and deny its novel motion for notice of impeachment outside the presence of the jury. So what this tells me is that she may have some evidence that may come in as hearsay herself, or she may have some statements that won't be hearsay, but some statements that was made outside of the, maybe in the media or something like that, that she may usher in, right, to use as a part of her defense. So now, Teen Tails, you're getting what you're asking for. Possibly. So now, all of you remember, y'all say, oh, but they lied here, they lied on this interview, they lied here, lied whatever. She might be bringing it in. Okay, she might be trying to get it in, right? Let's see. I mean, who made inconsistent statements under oath? Oh, you know what? Also, she may use the fact that whatever they said in 2008, or what, remember they said, this didn't happen, that didn't happen, whatever. She may be bringing that in too, because it says under oath, right? And that's one of the places I could think about, or what they said during the trial at that time under oath as well. So whatever they told the police, and whatever they told came in during that trial back in 2008 or whatever, and was said under oath when in that trial. So that's a good play. Number 9, motion to preclude argument designed to elicit jury nullification. The motion acts to preclude evidence or argument that it characterizes as designed to elicit jury nullification. And that just means that the jury should automatically, evidence that says the jury should automatically find you guilty, no matter what. It says including that of a penalties faced by defendants if they are convicted. B, outrageous government conduct. C, government's motivations in prosecuting the case. And D, selective prosecution. Motion 27 to 33. Mr. Kelly has no intention to argue jury nullification and objects to only to the extent that he intends to expose every weakness in the government's case, including the government's conduct and tactics that affect the veracity of and reliability of evidence. So this is telling me she gonna show her ass in the people courtroom. That's what it tells me. Yeah. And she's telling them that she's going to accuse y'all motherfucking ass of all kind of shit, and probably including fucking with the black man all the time. And you don't fuck with the white man when they faced with the same crimes. Yeah. She's going to show ass. Number 10, it says preclude discovery request or commentary regarding discovery in presence of jury. Mr. Kelly does not intend to have discovery disputes in front of the jury and questions whether the government is anticipating not having produced all the discovery. If the government produces undisclosed evidence at trial, Mr. Kelly's counsel cannot promise to act unsurprised, but will conduct herself appropriately. So she's confirming to me that she's going to show her ass on another matter. Go ahead, J-Bo. J-Bo letting you know she's going to show her ass in the people courtroom. How much it costs to get to Chicago? Damn, y'all, somebody put my cash app up there so I can go to Chicago. I'm just playing. Oh man, that is, I like that. Oh, I like that. That is crazy. She said Mr. Kelly's counsel cannot promise to act unsurprised, okay, but will conduct herself appropriately. She's probably, Your Honor, object. 11. It says exclude evidence or arguments regarding the constitutionality of the statutes criminalizing the production and receipt of child pornography. Mr. Kelly has no objection. Wait a minute now, hold on. Exclude evidence or okay. I see. Okay, I see why she would go along with that. Okay. All right, because it's the law. So there's no reason to object to it. It's child pornography. It's the law, you know. So it says preclude argument or evidence of defendant's non-pertinent character traits. Mr. Kelly has every intention of abiding by the federal rules of evidence and reserves the right to introduce relevant and probative evidence at trial. Defendant does not intend to affirmatively introduce evidence of good character. So that just means that, like I said, how these people we around here talking about why you didn't go take the stand to be a witness for R. Kelly, why you didn't do this and whatever. It's the same argument here, right? And testimony is evidence. So his character traits and things of that nature, she's just pretty saying that she's going to abide by the rules of evidence to get evidence with regards to his character traits in. Remember, witnesses just can't come up there and just say, oh, he's a good person or whatever. You got to have some type of, it got to be a trait that you're talking about. Like, well, for 30 years, he's always been involved in the, breast cancer charity or whatever. And he's done this, that, whatever. So it's just a character, a trait means that that's how that's naturally in you. And number 13 says preclude defenses of alibi, unavailability, and mental defect. Preclude defenses of alibi, unavailability, and mental defect. Okay, let me read this. It said, with regard to alibi evidence under Rule 12.1, it is currently impossible for Mr. Kelly to provide an alibi because the government's allegations identify almost no specific dates and span at least 20 years, with the oldest approximation placed somewhere in the mid-1990s. Remember when I told you on that indictment, I kept saying those years from here to this, whatever. She's hitting it. Yeah, she's hitting it. Because if you said I did something and you talking about I wish somebody was underage, and you said you got evidence of it, you better well tell me and show me that I did it on that particular. It could be off a day or two, but the year gonna be, you got to have that year right? Oh, let me see what she say. Oh shit, let me see. Let me start over a little bit. It says, with regard to alibi evidence under Rule 12.1, it is currently impossible for Mr. Kelly to provide an alibi because the government's allegations identify almost no specific dates and span at least 20 years, with the oldest approximation placed somewhere in the mid-1990s. Meaning he can't say, remember I said, if he had somebody in the say or something, a proof to say, okay, they say on January the 1st, I'm putting on your birthday, January the 4th, 1993, you was on the tape with somebody underage. Well, if he could have been actually at a concert. But she's saying, well, I can't make that claim because you don't have specific dates. Ooh, she picked it up. It said, if it becomes clear at trial that Mr. Kelly has an alibi defense, he may very well raise it. At this juncture, it is not possible for Mr. Kelly to provide notice of an alibi when he himself has no notice of the times or dates he may have one for. Mr. Kelly is not planning to raise mental defect under Rule 12.2. Hold on. Okay. At this time juncture, it is not possible for Mr. Kelly to provide notice of an alibi when he himself has no notice of the times or dates he may have one for. Okay, period. And it said Mr. Kelly is not planning to raise mental defect under Rule 12.2. Okay, y'all, I get excited. It's number 14. Preclude defense counsel from defining term reasonable doubt. Mr. Kelly has no response to this motion and states that he is represented by experienced counsel who will represent him competently which means, and I thought that was crazy when I saw it in there. Like, okay, she knows how to raise reasonable doubt without running around the court, you know, having to define over and over again what reasonable doubt is to the jury. That's the judge's job and all of that. She's going to lay out her case, to which she's going to, build reasonable doubt throughout, how she present her case in chief. It says, allow government to call case agent during case in chief. It says, Mr. Kelly objects to the government's open-ended motion to especially recall its own investigator, while Mr. Kelly does not dispute that it is within the court's discretion to exercise reasonable control over the mode and order of examining witnesses under 611A, recalling a witness as untold number of times presents a serious risk of prejudicial overemphasis on the witness's credibility and undue lengthening of the trial. Because remember, you do direct, you do cross, you do redirect, you do recross, and then right after that, then it kind of gets like, as if the judge permits it, because it gets kind of shit. Case law. It says the Seventh Circuit of 1982 for the proposition that parties to a criminal case have an interest in limiting recall of witnesses. Case law. It says Seventh Circuit of 1993, acknowledging the risk that one side is given an unfair opportunity to strengthen its case, as well as perhaps unduly emphasize certain testimony when a witness is recalled. Consequently, Mr. Kelly objects to the government's motion and asks the court to use its discretion to appropriately limit the agent's testimony to prevent undue emphasis and keep the trial as balanced as possible. 16. Admit business records. Mr. Kelly has no objection to the admission of certified copies of domestic business records pursuant to rules 903.11 and 803.6, contingent on the government's agreement for reciprocity when and if Mr. Kelly seeks to introduce the same reference. Kelly reserves the right to object on relevance grounds. Conclusion. For the foregoing reasons, defendant seeks an order from this court denying numbers 2, 3, 5, 7, 8, and 15 of the government's motion and granting the motion with respect to number 4. Signed, Jbo'. Let me come around here with y'all. So, wow. Yeah, let me see what y'all talking about. This is crazy. She is trying to show her ass. I got to go to Chicago, y'all. Yeah, so okay, all right. She's getting down with it. So, Karen, so you remember that. What's good with it, Courtney? So you remember that. Remember, I was telling you, you got to have, ain't no way in the hell you're going to come in there with me. Ain't going to talk about, my client done something like this, and you got a span. I said that when I first saw the indictment, I said, "Ooh, the government, they gonna have to tighten up on them years, and because ain't no way in hell you gonna come here and tell me that, okay, well, it was either in 97 or 98. That's a whole year. And if you said you got evidence, well, your evidence should tell you what year it was. That's your goddamn, you the one brought us here. We say we wanted to come here. You the one filed charges on us. Get your shit together and call me when you're ready." Yeah, like, what the hell? So, yeah, she picked up on it. She got it. She's not fucking around. This is crazy, crazy, crazy. Let me see what y'all talking about. Hey, y'all, just dropping in front to go to sleep. All right, Regina White. Hey, LaBelle Marshall. Trouble. QE. It's a family against him. Not with you. Sonya Davis, what's good with it? I thought the government wasn't concerned with the results. I can't remember what they put in the motion of limine with regards to that, but she is fighting to keep the results out, and she has a good a good argument, because like the results really doesn't matter unless unless the government's going to say you can't really say the government. You could use that to say that the people understand is saying they told the truth then, they telling the truth now. Can't do that. Yeah. Unless it's more about the questions. Maybe it's more about the questions. Because she just hit on the results. Maybe it's more about the questions. Says, made her laugh at what? She had the tape. She gave them, hold on. After she gave him a cookie and was supposed to be the big original. She stole the tape. Original killed thing, even though she had the tape until she said something. She wanted money. Yeah. Yes, Minya. Yes, let's get those likes up. LG Munching got her number. Yep. She gonna put on the clown shoe. Yeah, she gonna show ass. And I like it. Okay, Courtney. I like it. She gonna show her ass, and it's supposed to be good. You got country my ass is thanks to be good. She don't hear that shit. The hell you mean? You don't know the damn date. Huh? And you got specific, but see, if that's the case, that would call into question the evidence. So that would call into question of the evidence. If you don't have the specific date, now how you come telling me I did some shit? I'm so tired of this naked goddamn shit. Hold on for a minute. Let me try to block that. Miss Courtney, what's going on? What's on
What's
your mind, lady?
what's good? What's good with it?
What's
Now
good with it?
I came in, I ain't catch it all, but I've been following now, and you will give me. Hey, what's going on, everybody? Our channel. Now remember when I came on there before, and I told you that I said, "Shit, this shit got to come on with the come on." Because if you accusing me of something 20 years ago, I want you to tell me what I had on.
Yep.
When was it? What year was it? What was it raining outside? She about to cut the fuck up because
Yeah.
you ain't gonna get me to see because I get excited when we get to winning here when she get to getting when Jbo gets up in their ass because now let's rewind back to LaShonda Landfair when you read with Mel Brown. They went to the Cancun or wherever the fuck they went to. They went to the grand jury right after that, and then whatever year that was, the trial wasn't for 6 more years. You had 6 years to come and tell this shit or what you thinking or what you making up. How can you remember all of this?
Right.
You see what
Yeah.
I'm saying?
Yeah. I mean, that's a long period of time to try to defend. Well, but you better have my dates right, or it's
Yeah,
gonna be some shit. Like what?
yeah. Because when when I listen to the readings, and I pull it up, it says from 1996 to 1998, or the beginning of 1996, 1997. Damn, that was a long. That's a long time back. And I got to
Mm-hmm.
shout out to the supporters for Robert Sylvester Kelly, because we in this fight, for the man to get a fair shot at this shit. Cause this shit is more than a goddamn notion.
Yeah, yeah, it is. It's off the chain.
It,
Cause I mean, that's just crazy. That, but she picked, boy, she is not playing. She telling you, she gonna show her. That's funny as hell to me. I can't wait somebody to come back and report that shit.
mm-hmm. Yep. But ain't now this ain't gonna be all closed off. They gonna let people in for this one, ain't they, Angie?
Yeah, they don't let them in. Just won't be on TV. But yeah, they don't let them in.
But it ain't gonna be on TV.
Not this one. Nope.
Now, what was this I heard about the government and one of them motions or whatever they put up, whatever you call them? They said that they got statements. They not gonna have physical witnesses. They gonna read the government witnesses statements. Can you do that?
Okay. Now that was yesterday's, right? And
Yeah.
I wrote a whole summation on a little recap on the wall. So here's what it is, right? So they have statements, and apparently they got statements from possibly his co-conspirators. That
Right.
means maybe McDavid and Brown, maybe some people that we don't even know, that's not even named in whatever, that maybe had something to do with it. Maybe some people they talked about it, told what happened,
Mm-hmm.
things of that nature, right?
Mm-hmm.
They're trying to get those statements in. Okay. So it may come up with an issue with regards to hearsay and the right to confront the person that make that statement, right?
Got
Because they won't be on the stand. Now, and now the person, the co-defendant, they have a option on getting on the stands or whatever, but that's likely not to happen. So you got these statements.
it.
So
Mm-hmm.
apparently, so it doesn't mean that they not won't be allowed on the stand, but they just won't be available, or they don't need to be. That the statement is serving to prove something, something else with regard to the conspiracy, right? So
Mm-hmm. But
yeah,
see,
so
but my thing is too, cause see, I don't know. I come on your channel. I try to I try to look at it as far as whatever they saying about the law, but
mhm.
they making this shit up every day as they go to me. This is like a just so full of a cesspool of lies to me. I mean, okay. What I'm saying is, how in the fuck? Because you with these timelines from 1996, then this girl Lisa Van Allen, she was around. If you do her timeline, look like she was around for 4 years to me. Then in that same breath in that time, then this videotape was supposed they supposed to see. I feel like the federal government is painting this man out to be a fictitious ass motherfucking like uh mob boss, cold conspirators, cold defendants, and without just coming out to me with evidence. These are just testimonies to me, Angie.
Well, they're a little bit more than testimony.
To
Well,
me,
but testimony is evidence.
but what,
Latrice, there is no double jeopardy and statute of limitations in these cases. They circumvented that by the nature of the changing the jurisdiction and changing the
mhm,
charges.
yeah, because see, it sounds like some of these people shouldn't even be in this. To me, That's the way I look at it. Some of these people are, are not credible to me at all. If I was looking at it as the eyes of a juror. Some of them not credible to me. It seemed like this is staged to me. It seemed like they telling, see you know, especially when you rewind back to the New York case, you know, and the evidence and all this and all this, it seemed like they just made this shit up. Like when you listen to Lisa Van Allen, she paint a picture. When you listen to her whole full interview on Vlad TV, it's as
Mhm.
if she paints a picture like she didn't get along with her foster parent. That girl was a runaway. That girl, and she was 17 years old. I'm see that them be the eyes that I look at, you know, and it's unfortunate, you know, fortunate, unfortunate, but you can't get me to see how these are, whatever crimes was committed, you can't get me to see that a person supposed to get 30 years for this. These it seemed like, you know, it should be like whatever it is, it should be like this set amount of time for this charge, this set amount. Okay, and I'm gonna ask you this: how much time? Not a RICO. Do a person get if they however he did it and married married an underage person? That shit don't carry no 30 years.
Well, okay.
Oh
I
nah, yeah.
don't. I don't think. Hold on. I don't think. Cause see, every alleged crime doesn't. I'm not gonna say that. I don't think that there is a statute for a law for the marrying of an underage girl. I don't, that's why they went the route of bribery. And see, that would
Right.
be, if it was, there would be something dealing in state. But here's the thing, like I've explained before, they don't have to charge you by what we think he should be charged by, or what y'all think, or whatever. They gonna charge him for whatever fits. And if something in the feds fit, and they can bear out the elements, that's what they're gonna charge him with. Let me answer the couple of these questions. It says, would this old stuff under the old statute of limitation, which would be have expired by some of like, yeah, if it was under the old statute of limitations and if it was state. But remember, they amended that law before it ran out to for it to go back. I forgot how. I think it's unlimited. Without an age limit or whatever. I forgot if it's an age limit or is it the 25 or whatever. The I would have to look that up again. But they they redid that law, which allowed these charges to be brought forward from back in the day. So but under the state, yeah, the state would have. Let me answer this. Latrice says Aaliyah was brought up in the 2008 case when RSK was acquitted. Currently, she is deceased. She can't speak for herself. Her mother said, "Leave her child alone," and it's all alleged there's a gag order on Aaliyah case. I don't know, huh? Okay, because here's the thing, right? With the Aaliyah situation, even though she was brought up in an old case or whatever, that don't have nothing to do with a charge being brought with regards to her. Remember, the United States does not bring charges on behalf of people or whatever. They bring charges on behalf of the United States. So they could, if they have they brought up bribery as a predicate. They brought up bribery as a predicate act. They put it up under RICO, RICO, the Racketeering Act, and that's how they process that. The law is not going to be concerned with her mama saying leave her child alone. They don't care about that. If they
No, they don't.
find that it's a crime, they find it's a crime, they're gonna stick it wherever it fits, and they're gonna try to get it. They're gonna try to seek a prosecution for it. Um,
Well, what kind of laws do they break to do all that? Because that's what it sounds like to me.
No, but they're not breaking a law. They going by the law to make it an action that can be charged as
I know,
illegality. Hmm.
I just be saying that
Oh,
to
I
get the
understand.
perspective
I understand. So yeah, that they
of what how we be thinking.
right. Let me explain to Latrice what this double jeopardy is. Right, and please understand this. Double jeopardy. In order for somebody to be charged with double jeopardy, right, a lot of things have to happen. One, you got to be charged with the same crime, pretty much with the same elements, and it's usually in the same jurisdiction. In this case, he's not being charged with the same crimes, and he's not being charged in the same jurisdiction with the same crimes. The elements are different. That's how they evade the double jeopardy. So I don't care no matter what you hear on these streets, it is not double jeopardy. It is not barred by a statute of limitations. If it were, we're on 7/18. The case started on 8/15. Any lawyer, any idiot that's working in a lawyer's office, when that indictment hit their desk, I'm talking he done had a million lawyers. One of them had to be competent. Would have put a motion in for this motion to dismiss based on the charges being double jeopardy or statute of limitations. Or because see, I say this all the time, the best way to beat a motherfucking case, a charge, is to get rid of it. That's an easy walk in the door. He'd
Mm-hmm.
have been home long time ago. That's the first thing, one of the first things you're gonna look for. Something to dismiss that shit doing what? That paperwork goes in with regards to a violation like that, because that's the law. That's somebody's rights. That isn't even up for negotiation. And it has that paperwork has gone through the hands from the 2019 all the way to this day. And if Jbo haven't seen, if you ain't seen a motion to dismiss by Jbo yet, that's telling you for double jeopardy or statute of limitations. And even if she did put one in, it's gonna get denied because it doesn't meet those standards, those qualifications. So that ain't gonna work out. Okay, Latrice, because I know right, and it cringes my soul. I just wish some people, like, if you trying to remix the law, if you don't know what the fuck it is you're talking about, whatever, just don't say it. Because I'm going to come out, and when I'm asked, I'm going to tell the truth. And I'm going to use facts because I'm going to show that there is a case still pending. Ain't a goddamn lawyer on this earth. Ain't one that haven't even taken a goddamn bar. Not one that even take one probably have taken the LSAT, maybe a L1 would know that time you get a some paperwork, that's the first shit you go to look for. Does this? Hey, did it make the time to file it? Uh, is it double jeopardy? And even if you want, and you put that paperwork in, and then that even if you're not sure, you think it is, but you ain't sure, right? You put that motion in. That judge is going to determine it. Yeah, ain't nobody finna risk. Nobody finna go to. Nobody finna goddamn risk they goddamn licensing, they job and shit, and all of that for sitting up there trying to prosecute somebody on the shit double jeopardy and goddamn statute of limitations. God damn! Oh my gosh, naked. What do you want?
But I think sometimes the reason why they, because I get it ain't no double jeopardy. I think sometimes the reason why they keep asking that question, or people, been screaming it, for so long, is because the mentioning of Rashana Landfair, and what she is, they saying that she's about to testify for, you know, by them thinking, and the allegedly, or the rumor on the YouTube streets is that she's coming to say that that was her on the tape, but they charging him with bribe, extortion, paying her to be quiet, right?
Mm-hmm.
Right. Well, still, they still ain't proved that to me, because the way that I don't know if I heard you right. They saying they was out of town. All of them was out of town, and when they came back, she testified, and the daddy testified to the grand jury. Shit, they was back then. When what you paid them to go out of town for what? Shit, they was around for 6 years.
Yeah, but they later, I think, if I'm not mistaken, I think the date they used, the crime was found, I think it was in 2014 or
Mm,
something like that, because they had to charge by 2019. That's when the crime was founded, that the obstruction had taken place with regards to that trial. So now you got obstruction charge of all of that happened in 2008.
right. I've been
Right.
I comprehended, how to
Yeah.
go,
Yeah.
how to go back that far.
Yeah, so she's saying that she was, so her whole thing on the stand now is that she was told to lie, and they sent them out of town to avoid, the whole conspiracy thing, the
Yeah,
whole
the people
obstruction thing. Yeah,
died, or who died you
yeah,
on. And it's the wording that they using to paint this man out to be like he orchestrating a hit. Come on now, like these people were scared for their life. I don't
right,
believe.
right. Yeah, I mean, they was
Come on
using
now.
language in the paperwork. They're saying, who team are you on, or whatever I read.
Yeah, who team are you on? Pick a side. And they trying to me, they trying to develop a pattern of that. That's the wording that they always saying. He said this man was singing and making hits. Shit, the fuck. That motherfucker singing and making hits. That motherfucking you know what? I can't even really, divulge my whole thought process on that motherfucking crooked ass Daryl McDavid. See, I'll keep that to myself, but that's I done caught on to this shit with the wording of way the prosecutors write this shit up.
Right, right,
Using this specific, type of language, like he's sitting and done called a grand meeting, and done told them, in other words, if you open your mouth, we gonna kill you. Ain't
right,
nobody
right,
did no shit like that. Not for no all these goddamn years walking around freely. And for one thing too, this shit is so fucked up. All of these people knew each other.
right.
Everybody knew each other. You ain't gonna get me to believe that. Everybody knew each other.
Hey y'all, let me go back to that first area what I was talking about. Not to cut you off. That motion to preclude evidence of victim sexual history, because I'm sitting here rereading, right? So here's what it's saying. It says, accordingly, Mr. Kelly objects to the exclusion of one any evidence regarding sexual conduct of witnesses who are not alleged victims identified in the indictment. So he he actually wants that information in. He wants that information in with regards to their sexual conduct. He wants that information in. He wants any evidence that falls within the exceptions laid out in Rule 412B and 3. I don't know how that's going to work. And exclusions based on Rule 403 that is not narrowly tailored to protect Mr. Kelly's Sixth Amendment right. I don't know. Three, she might have a leeway, but two, when the rules are pretty much set and it's procedure, so that means it's primary law, then the judge has to follow it. Whether it's not going to be a situation where it's biased, unbiased, whatever. If the rule says to allow it, then he's going to have to allow it, or not allow it. He's going to have to rule either way. Now, but pay attention to what she did, right? She's saying, although there are the rules, but I need you to step outside that rule and think that maybe those rules, based on allowing that evidence may violate R. Kelly's rights, right? In
Mm-hmm.
that case, depending on how, whatever how he rules on it, whatever, that could generate case law. Because now he has to step out of it. You know what I mean? If he's going to go on his decision versus mandatory and primary law, you got to go based on his decision. That's when case law may be generated. So based on his particular ruling. If he just goes by what they say 4442, whatever it is, what the rules of evidence as for that particular area, then he would be fine.
Mm-hmm. Yeah, I really actually think he could beat this case.
You think so?
Mm-hmm. Yep, I do.
Oh, I
I,
don't know
I
about
mean,
that.
well, wait a minute now. What you say? Oh,
I don't know. I don't know.
wait a
I'm
minute
gonna, I'm gonna
now.
keep it
Wait,
100.
wait,
I'm
wait,
gonna keep it
wait, wait,
100.
wait, wait. Wait a minute. I don't want to be over. Well, I think some of that stuff. I don't know. I don't know if I'm looking at it right. I think some of that stuff she could file a motion, or whenever she go up to battle, she got something to work with these people. To me,
If she beats it on violations,
yeah,
if she beats it on some type of technicalities, and if she works her reasonable doubt.
that's what I'm. Yeah, yeah,
Okay, if she works that, okay, well that means, but I just want you to understand, that means that, let me tell you something. That means I'm saying, I know it's a bunch of evidence and people
mm,
understand and we got statements and shit, but I'm gonna need y'all to fuck the evidence and statements and shit. I'm gonna need y'all to listen to me.
yeah,
So she's going to be pointing away from the evidence to violations and technicalities and reasonable doubt. Not she's going to be doing a point that way in that direction, and the government is going to keep pointing to the evidence. So I don't know how that's going to match up. That's right there is going to be. Mm-hmm.
well,
Who gonna win that?
but they telling shit. It. Well, we got to may the best lie win.
Yeah,
May the best lie win. Let's come on with. I'm serious, cause
yeah.
may the best lie win. In this one right here,
Yeah, that's a pretty tall order. I have to give it to you. I give it to you. I ain't gonna lie to you, child.
yeah. I
I ain't
just
gonna
want,
lie to
but
you.
you know what? What you know what, Angie? I want to see her in action, cause she a cold
Yeah,
piece though. I
yeah,
want to see her out, cause she ain't gave up. I want to see her in action.
right.
All this paperwork and all this motions and Milton Brown's lawyer ain't no joke either.
Yeah, I like on Mary Judge, baby. I like her. I like her, honey. I like her. This is
She
good.
trying to move. She trying to move her way up the totem pole and go into private practice or something with criminal justice system because she fighting for Milton Brown.
Right. Oh, Alvaro, you got a good point. That makes a good point right there. But I like old Mary Judge. Mary Judge is baby putting in work, and then the fact that even Jbo, recognized her work by just adopting her work, jumping on her motion that she had already prepared. I mean, for FD, she should be proud, girl. She'd be like, "Ooh, gold star for Mary, gold star for Mary."
I'm telling
Yeah.
you.
I like her. I like her.
Now,
But
now, you know what? I got a good question. Are they gonna pick the jury from Chicago, or is this gonna be a
well,
sequester?
I haven't. We haven't seen a request approved a request to for a venue change. So yeah, most likely.
Mm-mm. Most likely. But you
Most
know what?
likely.
I'm learning. I'm like, there's a lot of people like Cook. What's going? They call me Cook. What's going on with R. Kelly? Because you know what? Outside of this, you be surprised how many real people believe it. Believe that the man was overcharged. They believe in. What I believe is let the shit fit the time. The
Yeah,
time is
I
the
get that.
time.
And I can definitely see the unfairness
Come on
for
now.
that. Going being able to go back. That's what I said. At least if you're going to be able to charge somebody that, in my opinion, this is my opinion. I would love to see, like, okay, maybe you got some police reports that you done went to put in during that time, that long time. You had counseling. You done showed where, I hate to say this, your ass and got on drugs because of you done experienced this particular, it was severely impacted your life. Because if that's the case, hell, I got somebody, I mean, hell, he's an ex-cop. I got somebody, I could put his ass, nigga done kidnapped me for almost 2 days and shit. Man, as a matter of fact, I don't want to start no shit. Like that nigga did me dirty.
Yeah, and you know what? My head hurts so much. You know what? I ain't nothing I'm talking about. I ain't had no record career. Well, shit, the nigga got on Dale King and said, "Could none of y'all motherfuckers sing? Goddamn, what
Yeah.
y'all? None of y'all. Could none of y'all sing?
Yeah.
None of y'all.
Girl,
There ain't nobody saying they head hurt. I've been tossing and turning all my life. I can't work. I'm on SSI. None
right.
of that. None of that.
Right. Yeah, that nigga had me running down the damn the river, what was it called? The boardwalk. That was used to call the boardwalk back then. Running, honey. I done escaped. Running to the damn Sheraton.
I didn't
Like
have no shoes on. The only thing I had was my jacket. Shit. And why? If they don't get the fuck on with this
yeah,
bullshit.
yeah, they had, boy, please. I feel like I could go down there and make a goddamn claim. Hell, all these goddamn years.
Well, shit, that's what the fuck. That's what that Kim Fox said. She opened up a 1-800 crime talk. Shit, if
Hell,
you anybody know somebody was something such and such from R. Kelly, please call 1-800 such and such. Ain't
well,
that
I
what?
should have called there and I should have said, hell, I ain't got nothing for R. Kelly, but I got something for Mr. Williams down here in Jacksonville. You should be able to find him because he is a cop. God damn it. Yeah, I remember the last time I seen him, honey, I'm in the grocery store. Now, at this time, I'm Miss Walker. I'm in the goddamn grocery store, and at the side of my eye, I saw him pass by. And I was like, and I'm trying to afro, I'm Big Bad Wolf. I swing and I bang with motherfucking bear claws, right? That motherfucking nigga had me in that motherfucker like a baby goddamn sheep shit. I done got frozen. And I look
Yeah,
out of my eye. I never get that. And I said,
never
oh Lord,
forget it.
please don't let him see me. Please don't let him see me. And that nigga slowly backed up with that basket. He saw me. He came right on down there. And I can remember my mouth just standing there open. I had seen a ghost. And he know I was terrified. But one thing I had in my pocket, I had a jealous ass nigga. I keep some of them.
You keep
And
them.
yes, because the grocery store was on the corner.
Mm-hmm.
And it wouldn't took him 5 minutes. Because if I take too long to come out of that goddamn grocery store, he's coming up there. He's coming anywhere I am. If I'm taking too long.
That's what I used to say. That's what I
I'm
used to
like,
say
oh
with these.
no.
That's what I used to say with these niggas. Y'all just don't understand. I got a pit bull at home. And all I
Girl,
gotta do is say something. And this pit bull is gonna come at your ass.
child, I'm trying to tell you how crazy that nigga. We was playing spades one day, and I wasn't his partner this day. I was this guy named Polo's partner. I'm sitting across the Polo, and he said, sweetheart, we playing spades. He's talking, sweetheart, how many you got? And here go this fool talking about, that's Miss Walker. I'm like, oh, god damn. Oh, god damn. The people can't even say, sweetheart, how many you got? I ain't got time for this shit. Girl, but
But
let me get up off here because I got an early day tomorrow, honey, and I'm
you
approaching 2 hours.
but it's always good coming in your chat. You
Yes,
know,
yes,
I
honey.
just came in to let you know I'm following and I'm listening.
I
And
see, I see. I appreciate you. I see, honey. We have
I'm
to make sure that
I'm here for the duration, and
good. We have to make
everybody
sure
in there,
the information is
I
correct.
yeah. So I'll be I'm gonna be in the chat room with you.
Okay, ma'am. All right.
All right, babe.
Thank you, ma'am. Oh, let me catch what Dolores said. Dolores says, since Lanford is getting on the stand saying that was her in the video, so when her mother testified saying that was not the daughter in the video, is she gonna be charged with perjury? They probably gonna work that out, so probably no. So if you're looking for anybody to be held accountable for some lies and all of that, that ain't gonna happen. There ain't no perjury or none of that. Because especially if they say that he, he told him to lie, whatever, and this is what happened. As you see in the other paperwork, they was saying like she was talking about she was afraid, their family was afraid and whatever. They already setting that tone already. So if y'all looking for perjury, anybody be held responsible, accountable, the answer gonna be probably no. They if they found any type of neglect already, or anything illegal that the parents did, they probably worked that out already. That's generally what happens. But y'all, that is my time. Y'all have been superior. And I just, child, y'all gonna have to work on them up that little motherfucking like button. I don't understand. Like do all this shit it says in there. I'm gonna need y'all to do all them little things that's coming at you. Look at Skylight bringing her ass on here. Hold on for a minute. Hold on, Sky. I see you. What's good with it? What's good with it?
Hey, look, I was trying to run. I'm like, hold on, let me get on record. I ain't
Hey,
gonna be long. I'm gonna be
what's
brief.
good with it, girl? What's good with it?
How you doing? Hey, chat.
Fine, honey, fine.
I want to say this. Nah, you know I can't take it. Bullshit ain't nothing but chewed up grass, and Bojine see that. Chat. How
Oh
you gonna come with a statement? I can't question a statement. I want to ask you what you was doing, how you was thinking, and why you saying what you saying. How can I question a statement? Number one. Two, the time span. When we first read that time span, y'all trying to go from 1902 all the way to 1979. No, no. That's why I think it's a win because look at the New York case. Oh, you had dates and times. On November 5th at 2:42, he was getting a ticket and flew her here. Why we ain't doing that in this one?
But
You see what I'm
I said before I even had this channel, I said when I first seen it in 2019, I said, oh, I said that this president, this government, they gonna have to tighten this up because if you got these dates, all these dates, all you ain't talking whether 1999 or 1998, unless you saying something happened in 98 and 99,
there you go.
and then you say you got specific evidence to prove that something happened on a specific date. I said, oh, she gonna eat that up. Well, I ain't say she. I said, oh, their attorney will eat that up. Because
Yeah,
okay, well, how you know when it happened?
you don't. That's the whole
Because I
point.
can tell you, because I can say my client say, no, it happened in 2001 when your ass was 18.
There you go. And that's exactly what's gonna happen. They trying to throw some shit on the wall and make it a masterpiece. But you ain't no way you when I read they had the victims was age in between age 12 and 19 or something. Wait, what you mean? Was they 12 or was they 19? You see what I'm saying?
Yeah,
What,
yeah.
what's with the
Because it was no more than a year off, but even. But here's the thing, and then like I was used to say when the New York trial, he would have benefited. Like if somebody when somebody said, oh, he beat my ass on Friday, July 4th, and he would have benefited by having somebody up there say, well, I was with him on Friday, July the 4th. He ain't beat her ass. Or on Friday, July 4th, his ass was in Bahrain giving a goddamn concert and shit. Motherfuckers
That's
over there trying
right.
to blow people up, you know. But
That's right.
he said exactly what the argument is. Well, how is he gonna mount an alibi for one? That's just one of the situations.
Yeah,
And two,
right. That's just one.
you're gonna be
That's just
able,
one.
if you don't have the right dates, then how the fuck I'm supposed to say, okay, well shit, well I think, well since you think I'm on that video at that time with that girl, she underage, I think my ass was in Bahrain giving a concert. Like
There
what
you
the fuck?
There you go. Because unless they got something tangible, it's a loophole in my ass. Because
Yeah,
like you said, I'm gonna be like, no. I remember he was in butt fuck Egypt doing a concert at that time. Okay,
right,
so I
right.
mean, that's really all I wanted to get on record and say. I think it's a win because they don't have exact dates, and then they don't have. I mean, what's the statement? Are you trying to get a statement because this person doesn't want to testify? That's what it's looking like to me. At this point, I don't even think Rashawn is going to testify. I'm just going on record with that.
You
But
don't think so? But I don't think the statements are from her. And she and to be honest, they are everything is alleged in those indictments, the paperwork, and everything. And when it comes to somebody's testimony, they expect it. Now you don't know if they're gonna testify until they show up on when they asses in that stand right, in that seat. But she's
why
giving
are
us.
they saying Angie, that they want to try and present a statement and not a person? You
Hold on,
can't
hold on.
question a
But that's
statement.
other people though. Hold on, guy. That could be when they were talking about the statements. They weren't talking about. Let me make sure I get this right. They weren't talking about anybody named in the in the in the charge X, right? If I'm not
Mm-hmm.
mistaken, they are talking about co-conspirators. They're talking about people they probably talk to about what happened. They're probably talking about the co-defense because I did the live on that yesterday. So and I listed what would make those statements admissible, and the government. And you got to think now. You got to keep in mind because everybody's playing. They playing how they playing, right? The government's job is to try to shut down those defenses, as well as get as much as they can get in to block your ass, to block the defense in where you don't have anywhere to go. So now they have all all kind of statements by all kind of people with regards to that goddamn conspiracy coming in. And how they can get it in is because one, they're saying that it's not hearsay, and one that it's not testimonial. When it's not testimonial, it's not to prove something, it's only to support the proof of something, right?
Yeah, but I don't give a damn if it's to prove or support. I feel like if you gonna make a statement, whoever the hell you are, I want to question you. I want to
Right.
be
And that's
able
what
to ask you a goddamn question.
that's why the confrontation clause is coming up. And when I did a live while before this even came up, I talked about Crawford and I also talked about the Bruton rule. Right. I'm still waiting for that. In the latest in the other document, they brought up oh Lord, why is my goddamn keep talking. Well anyway, go ahead and tell me what you was thinking.
No, I'm just saying I don't care who it is. and what it's about, whether it's supporting or not supporting. I don't care if you, whoever it is putting that damn statement in, need to show up. Because I want to ask you a question. What if I had a relationship with you and you a sour thought because you ain't get the position that you wanted? You see what I'm saying? Don't just be trying to put no statements in and I can't talk to the person entering the statement. No.
But some of those rules, right? They're not bound by the rules of evidence and the hearsay rules, so they would most likely be admitted. You understand what I'm saying?
Well, you
So,
know what, then Vogene need to get some statements from some random motherfuckers and say, you know what I'm saying, and in support of Kels. Because if that's what they doing, then we need to match them toe to toe, neck to neck. That's just ridiculous to me. I don't
right,
even see how
right,
somebody could do that. It
right.
might be an
So,
old hoe that I was messing with. You see what I'm
oh
saying?
Lord,
And you gonna let the statement in without her being here? You know, because people have ulterior motives for doing things. You know, and unless you give me a chance to rebut and say something in regards to each statement to that person and question them, like, okay, well, you just mad because I had sex with your sister and not you, or something like that. You know what I'm saying? Like, I don't know. I just don't like it. My
right,
last thing is this, and I'm gonna let you get out of here because I want to hold you up. Is we know that this is not about getting the parents locked up. Yes, and they probably did work that stuff out because, like I said before on my life, this is about taking R. Kelly down. This ain't about no victims. This ain't about no uh, giving them justice for alleged abuse and crimes, all that. No, this is about taking R. Kelly down. That's why they're not concerned with what the parents did or didn't do. Okay, people, let's just get cut to the chase, get to the meat. They want Kelly. They gonna give these parents. They in the last trial, they gave the parents a pass. They gave the people that should have been co-defendants a pass. Okay, and because like Angie said, just because they, even if they did something, if they don't get charged, then it is what it is. They
right.
could decide to charge you or not charge you. Okay. So I see the light. Okay. Some people want to say, oh, the victims, nah. If it's about the victims, they would have gave them justification at the time the crime occurred. Okay. And it might not have been like you saying federal, it would have been a little state case. But I feel like they ain't want to spend the money because they didn't care. Okay.
Now,
Now they
I
able to
mean,
do a pile on. And
yeah,
huh?
and the priority, well, would be him, and they're saying because of the the crimes he allegedly committed. Oh, when I look back at the paper, they also brought up Borgeley, right? Which when I which is just simply means that they the those statements are not going to be bound by the rules of evidence, like I explained it on the board. So they covered all the areas in which those statements should be admissible.
Mm-hmm.
So that's what I'm saying. So I'm telling y'all right now, don't pass the fuck out, and don't and more important, don't come fuck with me and don't cuss me out. What I'm telling you, most likely them statements are coming in. They coming in. I'm trying to tell you. They
Bullshit.
uncovered it all. They said it shouldn't be bound by the rules of evidence, the hearsay rules, which are the
But
hearsay
how can they say
exceptions.
that? Is that law or is that what they want? Is that what
That is
they requesting?
no, that is the law. That is that is based on the co-conspirators hearsay exceptions. Hearsay exceptions. It doesn't violate the Crawford or Bruton rules, which has deal with violations when it comes to the right to to the right to whatever y'all know what I'm trying to say. I'm talking so goddamn fast. The right to confront your accuser, so
Punch.
it doesn't violate those laws. So they thought of everything. They raised Crawford in the paperwork yesterday, which they have been. And I said before they even did it, I said y'all look up for Crawford coming up. Look out for Bruton. Look out for hearsay. I did those lives on that. That's why I remember. I did that hearsay live because I knew it was coming up. But anytime you got co-conspirators and whatever, I
Uh-huh.
know what the defense play is going to be. I know what the motherfucking prosecutor is going to say.
Well, let me get on record with my fourth point, and that would be look for Bojine to have some statements for R. Kelly. Okay, I'm getting on record with that's my fourth point.
You gonna be the
We
you
gonna
gonna be
have
the
some
right, you gonna
statements
be the
too.
awful. Well, Bo Jean
Huh?
already said she's going to show her ass in the people court.
Oh yeah, because if you want to do statements, we gonna have statements. We doing what you doing, cause she petty like me. She petty. We gonna have statements too. Just
Yeah,
wait. Just
she put it
wait.
so she put it so white, girl. She said, well, she's not going to act like she's going to be unsurprised, but she knows how to conduct herself, which means that some shit comes up.
She ain't going. She is
Yeah,
not
she's
going.
gonna
She's not
object, but
gonna
she
do what
gonna
these
hold it up.
last horrible attorneys did. She ain't going. It's
She
not
gonna
gonna be
hold
what
up
you
the
saw in
goddamn
New York.
proceeding till the marshals come get our ass. That's what she gonna do.
Yes, she
I'm
gonna
be
fight
like,
to the
ooh,
finish.
ooh.
Yes, and I got her back 100%. I just feel like she ready. She sound confident in what she doing, and she gonna
Yeah.
attack everything. It's not gonna be no just a bunch of random people coming up there saying nothing. But I promise you, my point number 4 is look for us to have some statements too on behalf of R. Kelly. If they got 10, we gonna have 20 because
Oh,
Boji,
you gonna write them? Y'all got the witnesses and stuff this time. Y'all got it loaded up.
we gonna have no. We just gonna go walk down, have them go down Stony Island, and have some people write some statements. Cause where y'all getting these statements from? Y'all probably just stopping people in the store. Did you watch the
Oh God.
documentary? Do you not like Kels? Do a statement for me. We don't know where these statements coming from. I don't trust it. I don't trust it, man. And I'm going, and I ain't gonna keep you up. Let me look. We gonna have homeless people write statements. Yeah, but R. Kelly, I seen him. He wasn't doing that. I promise
Oh,
you. We
oh
ain't
shit.
going.
The
We
homeless
ain't
people.
going.
Oh hell no. I'm be like hell no. They got all these goddamn statements, boy. Oh baby, I
Oh yeah,
would
we matching you. We going. I promise you. If she don't, I'm gonna be shocked. Cause she see the
oh,
game they playing, and she gonna play that game. She gonna play that game.
she
Cause she
is not
gotta come with
playing.
something. But
Yeah, she
she
come with something. She don't want to hear that shit. The hell. Boy, I'm
coming
saying,
with an
boy.
old 20-year time span. Like you saying she gonna age him. Cause yeah, if you trying to lure him to make him 2 and 3, she gonna make him
Oh
19
shit.
and 20. You goddamn right. Yep, that's what we doing.
Right. So
We
that's why
doing
I
it.
don't know why they don't. I mean, they must be gonna reveal it sometime soon, the actual dates and shit. Cause I
They
know the
better.
goddamn people, the people, you done did your chain of custody, so you done authenticated the tapes. You know the dates, whatever. The people that's testifying and gave you the information, honey. Baby, Jbo'S said as of this day. Cause since they gives us she dropped the motherfucking blues clues for our ass. As of this day,
There you
we ain't
go.
got no goddamn concrete dates.
There
Hmm?
you go.
I
There you
told
go.
y'all, I told you, I knew it. Any competent attorney would have motherfucking picked up on that. Bitch, you got me fucked up. I what?
Right.
I ran a light at 3:23 a.m. Eastern Standard Time on today. I'm talking to Skylight. That wasn't me.
Right. Go to my YouTube page. I
Yeah,
was
go to
on
my YouTube page.
YouTube.
I was online.
Okay. I was in the chat. How about
Yeah,
that? Man, I
yeah.
know what she said. Yeah, ain't nobody going for that. Bojine is not going. See, that's what I'm saying. They got away in New York. They got away with having poor attorneys, and they ran amok and got kills them 30 years. Everybody knows that 30 years is wrong. Okay. Them thoughts ain't worth no 30 years. That's what I'm saying. It's not
Oh,
about that.
man.
It's about them being petty. Like he said, he been in the game for 30 years, so they want to run and give him 30
Yep.
years. Say, okay, well, let's get
Symbolic.
them
Yeah.
30 years back from your ass.
Yeah.
That's what that
Symbolic
is.
goddamn sentence. Yeah, but that's crazy. That
30
is
years
so
old
damn crazy.
body
I
and
can't wait. Sky, you got to go to that trial. You ain't gonna be able to go.
you know what? Nah. See, y'all played with me with the convoy. I wasn't doing it and I still ain't doing it. But now they got you got the monkeypox. I don't know what to do with y'all now.
The
What
monkey
is y'all
pox.
doing with
Oh
the
hell no. The
monkeypox?
monkey damn pox.
I don't know if I could do the monkeypox, y'all. I don't know. But I do want to at least go one day because you know what I'm saying. I've been out on medical, so you know what I'm saying. I don't sucked up a lot
Yeah.
of my time. So, but I do want to go one day just to, but I gotta see how it's set up. Because if it's you know what I'm saying, convoy and monkeypox super spreader, I can't do it. Dang.
Oh, okay. Oh
But
man, I need we're gonna have to get our own personal goddamn reporter from over this on our channel. We need
yeah,
our own reporter because I can like I tell you what I need you to tell me what the judge said. I don't want to just hear what the witnesses said and the
right.
attorney said. I need to hear what the judge said, what everybody said, because they be addressing things like because he likes to do a lot of oral orders and shit. That means he's gonna address them right there in court. He like to do a lot of that shit, and I need to have that.
Okay. We need two people then, because one person need to pay attention to the judge, and the other person need to pay attention to what the witnesses and
Yeah, I
and
need somebody.
Mojang.
I need to take it from the top. I don't need,
Mm-hmm.
that's fine. All that, from what the witnesses said and whatever. That's good. That's helpful and shit. But I need what that judge rule in and out. I mean, I love the transcripts, but I ain't got time to be waiting for them. I'm
Right, right.
impatient.
That's what I'm saying. I want to time it so I go on a good time because if they saying 4 weeks, I damn sure know I ain't got no 4 weeks. You know what I'm saying? It's a wrap.
Right.
I had it before, but it's over for now. But yeah,
Yeah.
if you do make it, I want to make sure I go on a good day. You don't want to go on a day when it ain't nothing happening, and you like I could have stayed home for this.
Right.
So,
That's crazy, girl. That's
but we gonna see
crazy.
how somebody going. We get it figured out. We get it
Yeah.
figured out.
Somebody got
I'm
to
gonna
go.
start asking around who going. You know.
Ooh, gone.
And we can see somebody going. If not the same people that showed up in New York, probably gonna show up in Chicago. I wouldn't be surprised. You
Yeah,
know,
that'll be good. That'll be good because if I just ask. I can tell nobody. I ain't trying to tell nobody what to do, but I just so appreciate if you get it from what the judge say too. Write
right?
down what he say. I need to hear that.
Yeah. One person do her. One person do her. Actually, you know what? We need somebody on everybody's attorney and the judge.
Judge,
This case
listen, what
gonna
you
be
say, lady?
crazy. Cause you said
Oh
McDavis attorney, and what's the other one attorney?
man, Milton Brown attorney.
Yeah, we need to hear what they saying too. Oh God, this is
Hmm.
crazy, y'all.
Yeah, we do. I need all of that. Let me see if I can put this idiot in.
But I'm gonna
Yeah.
try and see if I can go during the time when they do these witnesses and shit. And if these tapes, if I can get on a tape day or a witness day, I need to pull up. But I ain't gonna hold you because I know you finna get out of here. But we'll talk
Okay,
again.
lady.
Okay. All right.
All right. Thank you, ma'am.
All right. See you, chat. All right, Court.
All right, folks. I see y'all. Well, I sure enough do appreciate y'all this early in the morning. Y'all always around. I sure enough appreciate you. I appreciate you. I got to go and push on out, honey. 'Cause I got to be up in the morning. So with that being said, make sure y'all hit that like, share, and subscribe if you want to. And be good. Be good to somebody. Take care of yourself. I appreciate you and I love you. And guess what? There's another live in the books. Bye now.